Hi Prashanthi garu, how are you doing?
Hello, hello. How are you, Ranjit?
I'm good, I'm good. So yeah, this week, we'll talk about the L1 visa. That's a topic. So let's start with, what is an L1 visa and there are, two types in L1, I believe. So could you please shed some light on what is L1, what is the nature of L1B, and how long is it valid, and what forms need to be filled?
Yeah, sure. So basically, today's topic is L1, which is basically an intra-company transferee. L1 is often used in lieu of a H1. In many instances, multinational companies, MNCs, prefer to use L1s because there's no H1B quota. There's no quota on L1s, unlike H1s. So H1s, and also yeah, so they can file at any time. It's not like they have to wait until March every year to file and then, be subject to the cap. So, and also the other advantage of L1 is there's no prevailing wage in an L1, so you can really pay any reasonable wage and that should be fine. So oftentimes L1s, employers can get away by paying a lower wage than they would pay a H1. So that's the big advantage of using an L1 in lieu of the H1. But just to go back to your question, an L1 is an intra-company transferee, which means basically an employee from a foreign company is being transferred to the US company in order to either set up operations if it's a new entity, or to take care of the operations. So basically, one part of the company in a different country is transferring their employee to another country. And the reason they usually do that is because, unlike for the L1, it can be presumed that the employee has some specialized knowledge, some knowledge of the maybe how the company operates, the product. So obviously not anyone can take that person's place. So they can't obviously employ a US citizen to do the same job, because then they wouldn't have any knowledge of company product or the sales or whatever it might be, the unique knowledge or maybe the processes. So I guess that's the reason they came up with this L1 visa to start off with. Now, in order for an L1 to be filed,
Q&A session has started.
There has to be a parent company abroad, a company abroad, and a company in the US. Now, and there has to be a relationship between the two companies, the US and the foreign company. And that relationship is defined. It has to be either a parent and subsidiary relationship, or it has to be a branch, or it has to be an affiliate. An affiliate pretty much means one of the two subsidiaries, and both of them are owned by a third company. Or they are both of them are controlled by a third entity. That's an affiliate. So that plus the employee should have been working as a multinational executive. Should have been working in an executive position in the foreign company for at least 1 year. And usually the requirements for an executive position are not only that they don't do clerical work, and they have other people that they supervise. So these are the requirements. And they're basically taking care of policy, budget, executive type work, not clerical, picking up the phones, making sales calls. So there's a certain type of work that executives do, and it's basically, they have to be part of the policy and decision-making team. And they should also have supervisory duties. So these are the things. One, that there should be a relationship between the two companies, either affiliate, a subsidiary, or a parent. So basically a parent is, if the US company, if the foreign company is a parent, that means the US company should be owned completely by the parent company. by the foreign company, or it should own at least a controlling share in the US company. Then it's a parent. And a subsidiary is the company that is owned, that at least is owned by a parent and at least 50% or more controlling share again. Or all the shares are owned by the parent, or all the shares are owned by the owners of the parent company. So, it could be any of these relationships. I hope that's clear. Again, parent and subsidiary. So parent-subsidiary relationship, or the two companies have to be affiliates of each other, which means that a third entity owns them. Or they could be branch offices, which means an operating division or an office of the same organization just housed in a different location. So these are the different legal relationships that can be had in an L1. So that, and basically an L1 is given for 7 years if it's an L1A. Right now we're only talking about L1As, which are multinational executives. So they're given for 7 years, and you can file for. There's no labor certification requirement, which means it's an easy path to a green card. So you can file for an I-140 directly after 1 year of being in the US on an L1. So these are some of the requirements, what a L1 basically means.
Okay, sounds good. So what forms are used, like, for H1B, I-129 is used to file an H1B. So is it similar kind of form that's used for the L1A, or, are they directly applied consulate?
Yeah, no, you actually have to apply for, if you're doing just the regular L1A, you have to actually apply in the USCIS here. And it's the same form as a H1. It's the I-129 form. But when for H1 you use I-129 H supplement, the additional form, here you use the L supplement. So the supplement form is different, but the basic I-129 form is the same. And unlike the H1, there is no LCA requirement. There's no LCA that has to be filed. And because as I said, there's no prevailing wage or set wages that have to be given for an L1A. But it of course helps that if a higher wage is given, that is one way of showing that it's a higher executive position. If you're giving a lower wage, then USCIS might question what the level of the position is if they're not getting, a wage that is usually given to executives. It's possible. So that's what it is.